Welcome to Empowering Plans, a show dedicated to identifying waste and undue expense in the health benefits industry, discovering ways to maximize benefits while minimizing costs, and empowering employers, administrators, and consultants to emphasize, once again, the benefit in benefit plan. Today's episode is brought to you by the Phia Group, empowering plans since 1999. Now here are your hosts, the Phia Group's own CEO, Adam Russo, and Senior Vice President and General Counsel, Ron Peck.
And Brady.
Hello, everybody, and welcome to another episode of Empowering Plans of the Phia Group, Breaking News Story Edition. Is that what we should call this, Brady? I mean, what do we call this podcast?
I like Breaking News Edition.
The Breaking News Edition. I mean, at the end of the day, folks, here's what we realized. Anytime some breaking news comes out, instead of putting all these slides together, trying to get a webinar set up and getting people registered, we figured, hey, let's just do a quick podcast. It's a little bit more work for our producer, Pat Santos, but he's more than willing to do it. So today, we're having some breaking news. With me, not as always, but a frequent guest of ours. Whenever I'm not here, he's always here. Say hello to everyone to Brady Bizzaro.
Hello, Brady.
Ron Peck is not here because Ron has some real work to do today, Brady. Sorry, but we got to get him working on some other stuff to make the company some money. But Brady, this morning, I received an email from you, although I guess the entire legal team did, of some breaking news. I want to make sure that we give full credit where possible to our fine attorney here, Erin Hussey, who unfortunately decided to work from home today. So it's her loss not to be on this podcast. But we got this breaking news that she put together regarding the judge gutting the Department of Labor's Association Health Plan rule. It looks like it's a state of New York case versus the DOL that was published on March 28th, 2019, yesterday. Brady, in layman's terms, what the heck happened?
Wow, yeah. So it's a 47-page opinion, which I'll be honest, I haven't read all of it, but I read enough of it to know that basically this is a big deal. And one of the things I think is important for our listeners to know is that we don't just have breaking news podcasts for the heck of it. We only do this when we think it's a really big news story. And since AHPs are really hot in our industry right now, and people are looking forward to forming new ones, self-funded ones, that is, as of April 1st, the fact that this DC federal judge came out with this opinion is a big deal. Basically, I think the best way to describe what happened is to just back up quickly and talk about what the final rule tried to do. So if you recall, back in June of 2018, we covered this extensively, but the new AHP rules were issued by HHS. The goal in issuing the new rules was to loosen the requirements for associations of employers to band together and offer health insurance. So it was always the case that group employers could band together and offer health insurance, but they couldn't do so unless they met certain particular tests. And the court here analyzed the three of them. We'll call them just the purpose test, the commonality of interest test, and the control test. Those sound very boring. I promise you I won't go into detail too much on them, but basically, here's the deal. You had to have a sufficient business purpose if you were going to band together to sell insurance. Kind of makes sense.
So give an example of, let's just keep it simple.
Sure.
Business purpose, meaning what?
Meaning you had to all be relatively in the same industry. So
all right, so I am a hairdresser.
Correct, yeah.
Hairdressers are small shops, 5, 10 employees. So a bunch of hairdressers get together and form an association, right?
Correct. Yeah, that's the idea behind that. And the important point there is that being in the same geographic area wasn't enough. So just because you were all in Massachusetts wasn't enough.
So you would have to be not only all in Massachusetts, but all in Massachusetts cutting hair.
Pretty much. Yep. That's one of the most important tests here. And what the final rule did on that requirement is it loosened it. It said that actually geography was enough by itself. So you didn't have to have a really strong underlying business purpose.
So I could be a sub shop, a pizza place, a small retail store, a convenience store, and a hairdresser. As long as we're all in the same state, we can form an association and offer a self-funded plan, let's say.
That's correct, yeah. And that's one of the things that the rules did. The other important thing...
Which was great, potentially,
great
for the growth of self-funding.
Right. And remember here, the idea being here that Congress, in particular Republicans, wanted to make it easier for small employers and actually sole proprietors, working owners even, to band together and offer insurance and not have to deal with the burdensome regulations of the ACA as it applies in the large.
So you have 100 self-employed employers.
Yeah.
One-man shops, one-woman shops, who could all get together currently in Massachusetts and have a 100 life group.
Yeah, that was the idea behind this. And it's important to note that the final rule, adding this working owners provision, was entirely new. And that is really, I think, what is the most controversial part about the new rule, and it's what the court didn't like. The reason the court didn't like this is because, in its mind, group health insurance at its core is always about the employer and employee relationship, right? Under ERISA, that's what matters. They didn't want sort of a commercial insurers banding together to offer a commercial product. They wanted the purpose of ERISA is to protect employee benefits. So what the court looked at when looking at these final rules, it said, working owners banding together. You could have 51 working owners band together, right? And they form an AHP and they offer insurance to among themselves. And they don't have to comply with most of the ACA. And the court looked at that and said, why are we giving them the benefit of not having to comply with the ACA? These aren't really employees working for an employer. And so they felt—
It's not two separate people.
Right. And in fact, the rules kind of define a working owner both as an employee and an employer, which is not what ERISA says.
So is this decision limited to just those working employers?
There was two components here. Two provisions of the rule were vacated by this ruling. The first of which is the working owners one. So working owners no longer are going to be allowed to band together.
Got it. So if you're a one-man shop, you cannot band together create an association.
As of this morning, no.
But if you were a two-man shop, you potentially could, unless now you have the second prong.
Right. You have to be an employer with at least 2 employees under ERISA. That would be fine.
So 3 people.
Right. The second prong here is that the so-called bona fide provisions, which expanded to be just geography, right? That's also been struck down.
Why?
So now, because in the court's mind, there was not a sufficient underlying business purpose to your. So again,
so the court basically is going back saying you need an actual business purpose of banding together.
Correct.
But to me, isn't the business purpose the fact that you want to purchase employee benefits?
That was
because isn't it the second biggest expense that a business has?
Absolutely.
So how is that not having a business purpose when the second biggest expense you have is health insurance?
That's what people who wrote the rule argue. They said, look, our purpose is we want to offer cheaper insurance, which makes sense, but that didn't work for the court. It wasn't enough. They wanted something deeper and more of an underlying
tied to your actual business practices.
Yeah. So
now you're basically— go ahead. Sorry about that.
Just to say in a nutshell, what we want to focus on here is who this is going to impact. In our industry, not so many people. The reason is because the final rule actually called for— it set 2 target dates for when new AHPs could be formed. New self-funded AHPs couldn't be formed until April 1st, which I believe is very soon. But
right, so which is like 3 days from now. It's Monday.
Yeah. So there are no currently new
self-funded there are
AHPs.
TPAs that were listening.
There are
who have signed up clients writing their plan docs who potentially have an effective date of April 1st.
Correct. And there are some already existing AHPs who were allowed to add new members. And if they added some members who were working owners or sole proprietors, that's a problem.
So if you had an AHP right now of a bunch of hairdressers in Massachusetts, now that Hairdressers Association was able to add non-hairdressers because they were in Massachusetts alone, they would no longer be able to add those people.
That's right. Yeah.
Here's my question, Brady. It's a great job today. Is this. It says this is the state of New York versus Department of Labor. Is the entire country affected by this?
It is, yeah. So the name of the case is slightly misleading because it's actually 11 states and D.C. It just so happened that New York took the lead, as it often tries to do.
But it's 11 states and D.C., but it's not 50 states.
11 states brought the case, but the judge's order is effectively nationwide. And what the judge did, and it's important and sort of buried in the order.
How can one judge have that power?
Because he's a federal judge. And so he issues a nationwide sort of injunction. Because it was based on a rule, what he basically did was he vacated the rule, right? He said, more importantly, he vacated this part of the rule. He sent the rule back effectively to HHS and said—
to fix it.
Try to fix this. Because, importantly, unlike the ACA, which we'll talk about in a second, this rule had a severability clause saying if one part is found to be illegal,
then the whole thing's gone.
Right. It could be able to be saved. So the rule's been kicked back to HHS. If they're able to rewrite it, I don't think, though, that they're going to be able to rewrite it in the way that they want in the final rule, because the point,
couldn't this be sent to the Supreme Court somehow?
It eventually could be. That's the other option here, is that the DOJ is quote, reviewing its options. One of them is to appeal, which would be to the D.C. Circuit Court, and that could happen down the line. But a big deal, because there was so much hype and there's so much coverage about AHPs recently. People were calling us left and right, trying to form them, and it's exciting, a new way to offer affordable insurance. And all of a sudden you have this hammer sort of come down and put really a full stop on all these plans.
But the bottom line is, folks, if someone wants more information on what they need to do, or if they're still in compliance, they need to reach out to our legal team. I'm assuming.
We have a lot more on this, and like I said, we have like 3 people still digging through the order. We're going to have a lot more to say about this.
Now, for the sake of time, I know you brought up some issue with the DOJ in Texas Texas. You want to touch briefly on that as well?
Yeah, so this is the extremely important Texas Obamacare case that we've been following for a couple months now. The case where the judge in December literally struck down the entire ACA, and then he, stayed his own order while it's being appealed. That was huge news at the time, and the case has sort of been working its way through the system. It's going to be appealed to the Fifth Circuit Court in New Orleans, but importantly this week, the Justice Department took a different approach to this case, whereas previously the DOJ did not agree with the court ruling saying that all of the ACA should fall. They said, okay, only pieces of it should go,
right,
but the majority of the law should stay in place. Now they've officially changed their position, and they're saying, we agree 100% with the Texas federal judge, the entire ACA should be struck down.
Including the stuff people love, like the pre-existing condition exclusion.
Which was shocking to Democrats, shocking to Republicans, and more importantly.
Well, didn't President Trump just say last night at a rally how he would make sure that all people with pre-existing conditions would still be covered?
He did, yeah. And that's what's sort of shocking here is that I think, though, what's going on with some politics involved, but he also tweeted out that Republicans will soon be the party of healthcare.
Right.
I think the plan is to have them write their own law with those pieces that are popular in it. But to take this position, I mean, the ACA we mentioned in the webinar this year that it's the 9th anniversary of the ACA.
That's crazy.
It's been a long time. It's interwoven in everything healthcare, right? It's 20 million more people have coverage now because of it.
Are they just trying to give Phia Group more business, you think? That's possible, right? Redo all the plan documents?
That could be part of it, but they're really keeping things uncertain and unknown. And all the rules and regs that we thought were on solid ground suddenly seem to be shaky.
Well, as more information comes, I'm sure Brady and our legal team will keep all of our avid followers posted. Is that correct?
I absolutely will. Sure.
All right, folks, that's all the time for today. Again, thank you so much for joining us for our emergency, last-minute, amazing podcast. On behalf of our producer, Pat Santos, my co-host, the attorney, Brady Bizzarro, and myself, Adam Russo, thank you so much for empowering your plans with the Phia Group. Have a great day.